Good morning, everyone. This is Jennifer Lister. I'm the Vice President of Risk Management for Nonprofit Insurance Services, and we're here today to talk about medical marijuana and its impact in the workplace. Derrick Cox, who is a partner with Hurley, Rogner, Cox, and Waranch, is with us today, and he's going to go over the topic. If anybody during our session has questions, feel free to click on the question box, write up the question, and at the end of the presentation, we will make sure that we answer any and all questions. So if you'd like, Derrick, we can just kind of get a start.
Okay.
All right.
Thanks, Jennifer. Good morning, everyone. As Jennifer said, my name is Derrick Cox. I specialize in handling workers' compensation claims. I've been defending claims for NPIS now for a number of years. I've probably represented some of you on some workers' compensation claims that have been filed by your employees. And I appreciate the opportunity to come here and talk about a topic that's very interesting to a number of employers. It's very timely. There have been a lot of changes in the law lately involving medical marijuana. So let's go ahead and get started. I'm sure a number of you decided to attend the webinar today because of the following concern over medical marijuana. Probably concerned that this is the kind of workplace that medical marijuana creates. This may be another concern. Lawsuits that could be increasing based on the fact that medical marijuana is now legal in Florida. So basically, just a brief explanation. From a biological standpoint, everyone has endocannabinoid receptors. They're brain receptors, and either plant-derived or synthetic cannabinoids interact with these brain receptors, and it regulates your physiological processes, which include appetite, pain, and pleasure sensations, the immune system, mood, and memory. So, medical marijuana is now legal in Florida. So what happens, what's the process for someone who wants to get medical marijuana? Well, first of all, you have to be a Florida resident. And so you have to have a valid Florida ID to prove that you are a resident. And there's a separate provision for people who are seasonal residents of the state of Florida.
We're having a little bit of trouble. The slides aren't advancing on the actual presentation.
Give us one moment. Okay, are we up?
Yeah.
All right, thank you, Derrick.
Sorry about that.
Okay, sure, no problem. So this screen outlines how an individual can obtain medical marijuana. As I stated a second ago, you have to be a Florida resident with a valid Florida ID. And then you have to obtain medical records from your PCP, that's your primary care physician. And that's got to show what your diagnosis is. And in order to get medical marijuana, you have to have a debilitating medical condition, and I'll talk about that in a second. And then, so you get those medical records, and you bring those medical records to a marijuana evaluation appointment. And if you want it, you have to register with the Department of Health, and they've got a specific office on medical marijuana use. And there's the website for anyone who has any more questions in terms of if they're interested in obtaining medical marijuana. Are you advancing?
Yeah.
Advance.
See again. Audience view.
Okay.
Yep, we're good.
Great. So here are some general employment issues that come into play regarding medical marijuana. So from a safety standpoint, employers are wondering whether or not they'll be able to maintain a drug-free workplace. Compliance, how can employers with workers in multiple states comply with drug laws that differ from state to state? Productivity, will there be an adequate supply of qualified workers? Flexibility, employers have to figure out how they can staff these employees with differing jobs. And there's, of course, the concern over litigation. And we're going to address some of these issues during the webinar today. So here are some specific employment issues that we'll be talking about today. What's the impact of medical marijuana on pre-employment testing? What is the impact on ADA and FMLA issues? What's the impact on post-hire random and post-accident drug testing? What's the impact on workers' compensation, including what are our drug defenses, drug-free workplace, what kind of premium discounts are available, and whether we can be forced to provide medical marijuana. And then finally, there's questions involving liability for accidents by employees who use medical marijuana. So the legislation that started it all here in Florida was Senate Bill 8A that was passed 2 years ago in 2017. Governor Scott signed the bill in June of 2017. There was originally a 90-day waiting period that was removed. The statute that was enacted did not limit the maximum concentration of THC that medical marijuana can contain. So as a result, some medical marijuana products could be potent. They could contain high percentages of THC. Now, there was a second Senate bill that was just passed a few months ago. Governor DeSantis signed the bill in March. And so the new bill now allows smokable medical marijuana. And there are some parameters on that that we'll talk about certainly in a minute. Now, in order to qualify, if you're under the age of 18, you have to be diagnosed with a terminal illness. If a patient qualifies, then he or she cannot buy more than 2.5 ounces of medical marijuana every 35 days. The new bill that was signed into law prohibits smoking medical marijuana in a public place. It also prohibits smoking medical marijuana in an enclosed workspace or on public transportation. So there are certain limits on smoking medical marijuana that do not exist with other forms of medical marijuana. So what are some of the debilitating conditions that are contained in the statute? Here's a list. So the debilitating conditions include cancer, epilepsy, glaucoma, HIV, AIDS, PTSD, post-traumatic stress disorder, ALS, Crohn's disease, Parkinson's disease, and MS. But then the statute also goes on to say that there might be other medical conditions of the same kind or class or comparable to the ones that are enumerated above. So just because it's not on that list, if it falls into the same kind or class, or if it's comparable, then you could potentially qualify for medical marijuana under those circumstances as well. And it also includes terminal conditions diagnosed, even if it was not diagnosed by the prescribing physician, but if a separate physician diagnosed an individual with a terminal condition, then that would qualify. And then finally, the catch-all for that you can receive medical marijuana for chronic, non-malignant pain. So that's where quite a few people are going to qualify for medical marijuana will be under that category. And the qualifying medical condition information is found in the Florida Statute, section 381.986, parentheses 2. 381.986, you'll see that referenced a number of times in the webinar because that's the statutory section involving medical marijuana. So how is medical marijuana administered? There are oils, CBD oil primarily, and other oils. And as a result of the Senate bill that was just passed in March, some medical marijuana dispensaries have now begun to start selling whole flower smokable products as well. So, is there good news for employers? Which is why I'm sure everyone tuned into the webinar today. And the answer to that question, fortunately, is yes, there is good news for employers. So in the medical marijuana statute, fortunately, our legislature addressed a number of employment issues. So first, and you'll see the importance of this as we talk about some of the case law from other states, in our statute, it expressly denies a cause of action against an employer for wrongful discharge or discrimination. So what does that mean? Well, what that means is that our statute says that a discharged, terminated, or other prospective employee that's not hired because he or she is using medical marijuana will not result in a lawsuit against the employer. So that is huge. Number two, in the statute, it expressly prohibits medical marijuana users from using at their place of employment without their employer's permission. So if, as an employer, if you do not want any of your employees using medical marijuana at work, then you have the absolute right to require that and state that they cannot. Now, if you, on the other hand, if you are going to allow employees to use medical marijuana at work, then you can do that. You can give your employees permission. So it's going to be up to the employer. And then next, for all employers who have drug-free policies and programs, you can continue to enforce or establish a drug-free workplace program or policy. So if you currently have a drug-free workplace program or policy, that can continue. That does not have to change. If you do not currently have a drug-free workplace program or policy, but you want to establish one, you can do that now. There's no prohibition against that. So finally, from a workers' compensation standpoint, which is what is near and dear to my heart, the good news is the statute specifically does not allow reimbursement if an employer chooses to allow medical marijuana use by their employer. So that's different than the section that I'm going to be talking about in a second, but that says that if you choose to allow medical marijuana, you're not going to get reimbursed on your workers' compensation premium for that. Okay, so in 2018, it basically said the same thing about not limiting the ability of an employer to continue a drug-free workplace program. It also does not, under the statute, does not require an employer to accommodate the medical use of marijuana in any workplace or any employee working while under the influence of marijuana. So, and so that language tracks the ADA, reasonable accommodation, and we're going to be talking about the ADA in a little more detail shortly. But the good news is you don't have to provide a reasonable accommodation like you might have to in other circumstances because someone is using medical marijuana. And then finally, when it says this section does not create a cause of action for wrongful discharge or discrimination, so that means that you can discharge an employee or not hire an employee for using medical marijuana or having a medical marijuana card, and they cannot sue you. And then the final section that I was alluding to earlier, medical marijuana is not reimbursable under Chapter 440, which is the section of the workers' compensation statute in the Florida statute. So what that means is anyone who is injured at work and is looking for medical marijuana to be covered under workers' compensation, that is not covered under the Florida Workers' Compensation Act. So if they wanted medical marijuana as a treatment option for their work-related injury, they can get that, but they will have to pay for it on their own. It will not be something that will be paid for by us. Now, despite the clear language of the statute, there are a number of issues and questions. In fact, we may get to the end of the presentation today. In all likelihood, you will have more questions than answers. And that's pretty typical whenever a new law is passed, particularly a law as far-reaching as this medical marijuana law is. So there will be a number of questions and issues that'll be raised, and we'll have to deal with all of those issues as they come up. So the ADA, the Americans with Disabilities Act, as I'm sure most of you or all of you know, the ADA has been around for over 20 years now, going on 30 years, close to 30 years now. And the ADA prohibits employers of 15 or more from discriminating against a qualified individual with a disability. The ADA requires employers to provide reasonable accommodation so that any individual with a disability to be able to perform their essential job functions. And all of these buzzwords and phrases, I'm sure, are familiar because you've probably had to deal with one or more individuals with some type of disability at some point in time, and you've had to provide some type of reasonable accommodation so that they can perform their essential job functions. And depending on the case, the ADA may require employers to allow a disabled employee to take their medication at work if they need to, so that they can be accommodated to perform the essential functions of their job. However, the ADA does not protect the use of illegal drugs by employees with disabilities. And this is important because, as we'll see with the presentation, even though states have passed laws regarding medical marijuana, and some states have passed laws allowing the use of recreational marijuana as well, it is still illegal from a federal standpoint. So use of marijuana, either medically or recreationally, is still a violation of federal law. So the definition of illegal drugs under the ADA is derived from the Controlled Substances Act, or the CSA. And under the CSA, marijuana is still an illegal substance, so its possession or use is prohibited under the Controlled Substances Act. So next we have the FMLA, Family and Medical Leave Act. And the FMLA allows a qualified employee to take unpaid leave for up to 12 weeks. And FMLA defines serious health condition under this similar section of the statute. So all qualifying health conditions for purposes of obtaining medical marijuana will also likely qualify as a serious health condition in order to take FMLA leave. So, under the FMLA, an employer can be required to grant FMLA leave to a qualifying employee with a serious health condition. Now, the employer has to be aware that the employee may consume medical marijuana as part of his or her treatment during FMLA leave. So that it's now legal in Florida. If you have a qualifying condition that qualifies you to take FMLA leave, or an employee to take FMLA leave, that same debilitating medical condition may allow that employee to use or take medical marijuana as a treatment option while they are out on FMLA leave. So there's no case law in terms of whether an employee can terminate an employee who consumes medical marijuana while on a qualifying FMLA leave. And there's really virtually no authority on how you would handle random or reasonable suspicion drug testing pursuant to an employer's drug-free workplace policy or program once that employee returns to work once the FMLA leave expires. So these are some questions that will have to be addressed. So, and what's potentially more problematic is when an employee takes intermittent leave under the FMLA. So that can really pose some significant questions for an employer. So, for example, you're taking intermittent leave, you may be off work for a day or two or maybe a week and then come back and the employee hasn't used their 12 weeks, they're just using it as needed. And while they're off work, if they use medical marijuana, what are the employer's rights? What can the employer do? Can the employer be permitted to inquire whether the employee consumed medical marijuana while on leave? What kind of testing can the employer conduct once the employee comes back from these intermittent leaves? These are unanswered questions. Other aspects to consider regarding the FMLA. Is the employer a federal contractor subject to the Federal Drug-Free Workplace Act? If so, then it's going to be more stringent because, as I indicated earlier, marijuana is still illegal under federal law. Another question that'll go toward answering these FMLA leave issues, it'll depend on whether or not you as the employer maintain your own drug-free workplace policy. If you do, then what does the policy or program state? And that may guide some of the decisions that you make in terms of how you handle someone who's either out on FMLA leave or when they come back from FMLA leave. And then the other aspect is, does the employer prohibit the use of illegal drugs by its employees on or off of the employer's premises? So that'll be another question and another aspect in terms of what happens under the FMLA law. So here's another scenario or question. So what if an employee lawfully uses medical marijuana and it has a high percentage of THC and then returns to work and fails a random drug test? And then they're terminated as a result. What happens? How does the FMLA interact with the Florida medical marijuana law? Another question is, well, what happens if the employee sues, saying that his termination violates the FMLA? Can the employer rely on the CSA to support a finding that the employer did not violate the FMLA by terminating the employee who consumes what remains an illegal substance under federal law? So, and I believe the answer to that question is yes, because the FMLA is a federal statute, and medical marijuana and marijuana is still an illegal substance under the CSA, Controlled Substances Act. So I believe you could validly do that, but that question has still not been answered by the courts. So the good news is, if you do terminate an employee for using medical marijuana, the employee under Florida law cannot file a claim for wrongful discharge or termination. So even though some questions remain unanswered, Florida employers are learning more about their rights, and fortunately our statute addresses some things that other states did not put into their statutes that has already led to some litigation, and we'll talk about we'll talk about some case law here in a minute. So the next statute that comes into play is the Florida Civil Rights Act. So as I indicated before, the Florida's medical marijuana law expressly says that employers have no requirement to accommodate medical marijuana use for disabled employees while at work. And there's no cause of action for wrongful discharge or discrimination. So employers who do not accommodate on-site use of medical marijuana should not have employees try to bring any type of suit against them under either the ADA or under the Florida Civil Rights Act, because the statute is pretty clear, pretty specific on that. So we believe you would have a good defense if that issue was brought up. So an unanswered question is what happens with employees who use medical marijuana while they are off-site, while they are not at work. And our statute doesn't say anything about, employers and whether or not they have to agree that an employee is allowed to use medical marijuana while not at work. So there are some decisions that have come out in other states, and I want to talk about those just for a few minutes, just so you're aware of those. The first case is a case that came out. It was the Supreme Court of Washington State, Rhode versus Teletech Customer Care Management. So what happened in that case? Well, in that particular case, you had an individual who had debilitating migraine headaches that were causing chronic pain, nausea, blurred vision, sensitivity to light. The individual took pain medication, tried some other prescription drugs. Nothing was providing relief. So as a result, that employee started using medical marijuana. And it was allowable. She could use medical marijuana under the law of Washington State. So she then went to work, interviewed, and took a job as a customer service representative. Now, the job offer was contingent on passing a drug test. And they said that if you don't pass the drug test, then you're not eligible for employment. So, what she said was, hey, I understand that you have this drug policy. I've been using medical marijuana for this debilitating medical condition. And here's my paperwork. Here's my authorization. I'm doing everything in accordance with the statute. And she, took the drug test and started working. However, the drug test came back positive. Once it came back positive, she was terminated. So what happened? What did the Supreme Court of Washington do? Well, the Supreme Court of Washington looked at their state statute, and they said, you know what, our state statute doesn't say that an employer can discharge an employee for medical marijuana use. And it does not provide any kind of remedy for the employee. So as a result, they said that the employer was validly able to discharge that employee who was using medical marijuana, even though the employee was using medical marijuana in accordance with the state of Washington law. So basically, their finding and their ruling by the Supreme Court of Washington is similar to what our statute says, which is employer does not have to hire anyone, and the employer, if someone starts using, if a current employee starts using medical marijuana, then the employer has the right to discharge that employee, and the employer will not be subject to a lawsuit. So contrast that with the next case, which is a Rhode Island case. And in the Rhode Island case, there was a student at the University of Rhode Island obtaining their master's degree, and she was trying to get an internship because there was a requirement to get the master's. You had to apply and get an internship, and so she did. And the plaintiff in this particular case had a medical marijuana card, followed the law as it existed in Rhode Island, and she told the people where she was applying for the internship, the company, that she was using medical marijuana and that she had a card, and that she would test positive when she had her pre-employment drug test. Well, she did, and as a result, they said, sorry, we cannot hire you for this internship. So she filed suit, and in that particular case, the Rhode Island court said that her suit could proceed, that she was allowed to sue the employer. So why was that case different from the Washington case? Well, the difference between that case and the Washington case is because the Rhode Island law did not say anything about whether or not the plaintiff could sue the employer or could not sue the employer. And so they looked at it and they said, since the statute doesn't say that you can't sue the employer, you are allowed to sue the employer in this particular case. So her lawsuit in the state of Rhode Island was allowed to go forward. The third case was a case that came out of Oregon. And in Oregon, the facts of that case were there was an employee who experienced anxiety, panic attacks, nausea, vomiting, stomach cramps, and similar to the Washington case, that employee first tried a number of prescription drugs to alleviate the condition, none of which worked. So under the Oregon Medical Marijuana Act, that individual started taking medical marijuana legally, got the medical marijuana card, and then the employee applied for a job to work as a drill press operator. Started working as a drill press operator for the employer, and the employee was using medical marijuana, but using it at home, not using it at work. And the employee was doing a good job. However, the employer gave the employee a drug test, and the employee said, well, I'm using medical marijuana, so I'm not going to pass it. And sure enough, did not pass the drug test. So the employee was discharged, and the employee filed a lawsuit. And in Oregon, similar to Washington State, the Oregon court also found that the employee did not have the right to sue the employer. And their opinion was a little bit different, even though they came to the same conclusion as the Washington State court. They looked at the federal law, the Controlled Substances Act, and they said, this is illegal under federal law. So if it's illegal under federal law, then we're not going to say that you can sue your employer under state law. So as a result, that lawsuit was dismissed as well. So those are the three lawsuits that have arisen in other states, and so two lawsuits were based on what the state law said, and then the third law was based on what the federal law said. So my takeaway based on those cases, when you look at the Florida law, is we've got two defenses which will prevent an employee who uses medical marijuana from being able to sue his or her employer if the employee is terminated for a positive drug test for taking medical marijuana. Number one, the state statute says you can't sue the employer, and number two, it's still illegal under federal law. So, the Controlled Substances Act should provide Florida employers with strong defenses to support accommodation of off-site medical marijuana use. Question is, could an employer simply accommodate the employee's use of medical marijuana to avoid any potential discrimination or failure to accommodate claims? Yes, the employer could certainly do that, but you want to make sure that your policy is uniform. So a lot of the issues that you'll have to deal with will depend on whether or not you have a drug-free workplace program or policy, and if you do, what does that drug-free workplace program or policy state? So workers' compensation issues that come into play. Florida Statute 440 is the workers' compensation statute, and under Florida Statute 440.102, that is the specific section of the workers' comp statute that deals with drug-free workplace programs. And under that section of the statute, employers are allowed to implement a drug-free workplace program. And if you have a drug-free workplace program, then that will allow you to receive a discount on your workers' compensation premiums in certain circumstances. As I indicated earlier, it's right in the statute that under workers' compensation, marijuana is not reimbursable. So, and also as indicated earlier, if you do, as an employer, decide to allow medical marijuana use under your drug policy or program, you may not be entitled to the workers' compensation discount. The legislature did not intend for this new medical marijuana law to interfere with an employer's current drug policy or program, and it also doesn't prevent you from implementing one at this point in time if you have not done so already. So the one potential downside as an employer, in Florida, if you do decide to allow medical marijuana use at work, it could potentially increase your workers' compensation premiums. And of course, it could also pose some inherent liability and risk that would accompany any impaired employee at the workplace. So that's a risk that you'll have to take into account as an employer when making that decision. So any employer who's covered under the Federal Drug-Free Workplace Act should be protected if you terminate an employee who's using medical marijuana. So in Montana, there was one other case that found that the Controlled Substances Act preempted the state's medical marijuana law, and they dismissed the employee's wrongful termination claim. I didn't discuss that case in detail, but that was similar to the finding in Oregon, that federal law preempts state law. Now, and interesting, there have been no federal courts that have addressed this issue yet. These issues have only been addressed by the various state courts. So, Section 381.986 says that an employer is not limited in how it implements its drug-free policy or program. So you do have various alternatives or ways of how you want to do that. Now, if you want to qualify for the drug-free workplace program to get a workers' compensation discount under the Section 440.102, there are a number of requirements that you have to have in place in order to qualify. So in the the use of the word prescription is defined as any order for drugs written or transmitted by a licensed practitioner. Many practitioners can't or won't prescribe medical marijuana because it's a Schedule I drug under federal law. So some practitioners may only recommend that a person seek and obtain a medical marijuana card without actually prescribing it. So, and so one potential legal issue is, is a recommendation from a doctor, will that qualify as a prescription under the Workers' Compensation Act? That would require the employer carrier to take some action. We don't believe that that's the case, but there are some claimant attorneys that we know will be pushing the envelope and will be trying to take this issue up on appeal in the right case. So it's something that we'll have to be aware of and be ready to defend under the Workers' Compensation Act. There was a recent drug test case that came out just last year. And this was a case where an employee was injured. And because the employee was injured, the employer had the absolute right to conduct a post-accident drug test. The employer conducted 2 drug tests. The injured employee failed both of those drug tests. And as a result, all benefits were denied because under the Workers' Compensation Statute, if you fail a drug test and the employer is able to show that you had drugs in your system and the drugs were what caused or contributed to the injury, then you can deny all workers' compensation benefits. And the claimant in this particular case, well, first of all, the drug tests were administered right after the accident, and the claimant had signed a stipulation when she was hired, knowing that she was subject to drug testing, and she was aware of the employer's drug-free workplace, and she agreed to provide samples and be drug tested. So claimant knew about it. The drug test was done correctly, and under the statute, if you have a positive drug test, then it's presumed that the injury was caused by the influence of drugs. And the claimant in this case was not able to rebut the presumption that her injury was caused by her drug use, and as a result, her benefits were denied.
You know what I'd like to cut in, Derek, for the employers? On a work comp case, if you do deny it based on a positive drug test, I think we need to express the importance that that drug test needs to be done immediately. So if you do a drug test 2 days later, that's not going to help you with the claim itself. You can, terminate them based on your drug-free policy. But to deny a workers' compensation claim, it's really important that they're tested immediately right after the accident.
Yeah, that's right. That's one of the most important takeaways for every employer. Drug test the person immediately because if you wait, then it's useless. I've got a case right now where the employee had been smoking marijuana based on witnesses during lunch, comes back for lunch, working on I-4, fell 36 feet, significantly injured, went to the hospital. The hospital did not do any drug testing because the hospital is not required to do drug testing. The employer did not send over a mobile drug test company to the hospital to have the injured employee drug tested, and as a result, there was no drug test done, even though there were eyewitnesses to that event, showing that the person was smoking marijuana at lunchtime and was in all likelihood impaired at the time that he fell 36 feet while working on the I-4 overpass and injured. So it's extremely important to get that drug test done. If you've got a facility that you partner with, make sure that you insist that injured employee go to the facility immediately. And if they don't, then you need to tell them, well, you are refusing to submit to a drug test, because under the workers' compensation law, if they refuse to submit to a drug test, then that is a defense that we have as well. And if you don't already have access to, or a relationship with a mobile drug testing company, depending on what type, depending on if you have any employees that might be working in the field, you want to have a mobile drug testing company lined up as well so that they can go and get a drug, have a drug test done as quickly as possible. Extremely important. Thank you, Jennifer. So, anyway, this was the case that we've been talking about, and it was appealed, and it was affirmed on appeal, and the claimant filed a motion for rehearing, and that was denied as well. So that's a final binding decision denying all benefits based on the positive drug test. So, for those of you who saw the movie Fast Times at Ridgemont High, remember Jeff Spicoli. So what do we do now? Well, under a best practices approach, if you don't already have job descriptions for your employee positions, that would be a good thing to do. Make sure that the job descriptions are ADA compliant. Number two, take a look at any job tasks that are safety sensitive positions. Number three, talk to your legal counsel about rights and obligations regarding, substances in general, the medical marijuana laws, to come up with a plan regarding hiring, testing, and all human resources issues that would involve medical marijuana, such as some of the ones we've discussed today. And at a minimum, take a look at what current policy or policies you have in place. Make sure that the managers are trained and that they understand and that they communicate to the employees about marijuana use, both on or off the job. Once you've got a policy that's been approved by your council and it's been implemented, make sure that you inform the employees of all of the policies and any updates to the policies. And make sure that you train the supervisors and managers, including the training on reasonable suspicion for drug testing. So if you're regulated by the Department of Transportation or federal government in any way, you should have a zero tolerance policy, and that's because it is still illegal under federal law. Contractors should update procedures and testing so that there's some kind of mechanism to identify marijuana impairment on the job. If you don't already, you should make job offers contingent on passing a drug test. But if you do that, all employees in the same job have to take the test. You can't discriminate. And you have to make sure that if you do random drug testing, that it is truly random. And this is, again, under the drug-free workplace statute for workers' compensation purposes. In order to get a discount on your premium, you've got to perform job applicant drug testing. You've got to perform reasonable suspicion drug testing. You've got to perform routine fitness for duty drug testing. And you have to perform follow-up drug testing as well. And obviously, you don't want to give too much advance notice about any upcoming or pending drug tests. And you're probably going to want to have a specific policy involving medical marijuana use. We're already seeing, at least I'm already seeing, cases come up with workers' compensation claimants who have filed claims, and I'm taking depositions, and they have medical marijuana cards. So we're going to start seeing more and more of that, and if you're not already seeing some of that in the workplace, then it's only a matter of time.
Any questions? Any questions out there?
So if there are any questions, we've got a few minutes.
copy of the PowerPoint and then.
Yes, we're going to be sending everyone that attended today's conference a copy of the PowerPoint presentation, but we will also be having it on our Florida Insurance Trust website. It'll be under the members. You can go in there. Fit Members is the password, and it'll be under our webinars and presentations, and that should probably be up within the next 7 to 10 business days.
The second one, can there be a follow-up training provided at the educational conference?
We can look into providing an additional presentation on the drug-free workplace and medical marijuana. We'll definitely look into it. I know we're pretty packed already, but yes, we will definitely look into it.
And then the last one here, can FIT send us a medical marijuana policy for use on and off the job? Unfortunately,
with medical marijuana and the different members that we have, I would ask that if anybody has a question on a specific policy for your particular organization, just to please reach out to me directly at jennifer.lister@npis.com, and we can get you in touch with HR professionals, HR attorneys. FIT itself has a free HR hotline, and they can assist you with a medical marijuana policy if it's needed.
If denied as a workers' comp claim, can the employee sue the employer on civil law?
The employee can always sue the employer, but I'll tell you right now, there's going to be very little chance of any traction with that claim. I would find it hard to believe that if an employee is denied work comp benefits following an accident because they tested positive, there's not going to be a civil remedy. So, it only costs $100, unfortunately, to file a lawsuit, but that doesn't mean it will go anywhere. So the chances of an employee prevailing on that type of claim would be minimal. And even before the medical marijuana law was passed in Florida, we've seen a number of cases involving positive drug tests and a number of cases where claims were denied based on positive drug tests, and I never saw a civil lawsuit arise following a denial. So I would be surprised if that happens. Not to say that it's not possible, but the chances of prevailing would be very slim based on the current state of the law.
Will we be sending out a recording of today's webinar?
Yes, we will be sending out a recording of today's webinar. It'll go to everyone that has attended today. Again, you probably should look for that probably the end of this week or early next week. But yes, you will be sent that. And again, it will be on our FIT website as well. Is that it for the questions? It is. Okay, well, thank you so much, Derrick. I mean, that was very interesting and informative. I think the best practices at the end kind of gives us all an idea of where do we go from here, what do we do. I think the medical marijuana, having an actual policy for each member is kind of key. I think that was good advice and something we should all look into. Again, if anybody has a question later on, you're thinking about it later in the day and have a question, feel free to reach out to me. Again, this is Jennifer Lister, and you can reach me at jennifer.lister@npis.com, and I'll be happy to forward it to Derrick, or I'll answer it myself, but we will get you the answers that you need. And thank you, everyone, for attending. I really appreciate it. Thank you so much.